Hello and welcome back to the Deep Dive. Today we are stepping into the sometimes murky, often frankly terrifying waters of criminal law. I want to start by asking you, the listener, a question. It's a scenario that, well, it sounds a bit like a riddle, but it is very much real life. Imagine you have a brother. You two get into some trouble, maybe running a little illicit business, but then you get caught for something else. You're locked up. You are sitting in a penitentiary cell completely cut off from the outside world. And while you're sitting there, staring at the walls, your brother on the outside commits a crime, a tax fraud, let's say. Can you, the person sitting in that jail cell, be convicted for the crime your brother just committed?
It sounds impossible, right? I mean, you weren't even there. You're literally incapacitated by the state.
Exactly. It seems like an open and shut case.
Hmm.
But today we're going to find out why the answer might just be yes. We are looking at the concept of conspiracy liability, or what some people call being a partner in crime. It turns out the law has a very, very long reach.
It certainly does. Today, we are dissecting a landmark Supreme Court case, Pinkerton v. United States, from 1946. This is the case that established the doctrine known as, well, the Pinkerton rule. Our mission for this deep dive is to understand exactly how the law stretches criminal responsibilities so far beyond a person's own physical acts.
Just how elastic is that responsibility, really?
Very. We're going to examine the whole doctrine of conspiracy, and we'll look at how the Supreme Court actually rejected some previous limitations, specifically from a case called United States v. Sal. And then we're going to walk through a checklist to see exactly when you are on the hook for someone else's bad decisions.
Okay, let's unpack this. Before we get to the brothers at the center of this case, I want to understand the groundwork. What is the general legal theory that allows the government to charge one person for another's actions in a conspiracy?
At its heart, it's really a theory of agency. The easiest way to think of it is as a partnership in crime. In the civil world, right, if you and I are business partners and I go sign a contract for the business, you're bound by it too. Criminal law basically borrows that concept.
I see.
So the core principle is that as long as that partnership in crime continues, the partners are acting for each other.
So legally speaking, my partner is my agent.
Precisely. An overt act of one partner is the act of all, and there doesn't need to be a new agreement for every single act. Because you formed the conspiracy in the first place, you've effectively deputized your co-conspirators to act on your behalf.
Deputizing criminals. That's a powerful concept.
Yeah.
Let's analyze Pinkerton v. United States specifically to see how this played out. First, what are the legally dispositive facts?
All right, so we have two brothers, Walter and Daniel Pinkerton. They lived a short distance from each other on Daniel's farm. They were indicted for violations of the Internal Revenue Code. We're talking about unlawful possession, transportation, and dealing in whiskey. So moonshining and tax fraud, essentially.
A classic setup. And what were the specific charges?
The indictment had 10 substantive counts. So 10 specific crimes that were committed, and then one single count of conspiracy to commit all those crimes.
And the verdict from the jury?
The jury found Walter guilty on 9 of the substantive counts. They found Daniel guilty on 6 of them. And crucially, both brothers were found guilty on that conspiracy count.
Okay, but here's where it gets tricky, right? What was the crucial detail about Daniel's actual involvement?
This is the absolute linchpin of the whole case. There was zero evidence that Daniel participated directly in the commission of those substantive offenses. He wasn't the one, driving the truck or signing the papers. In fact, for some of the acts Walter committed, Daniel was actually sitting in the penitentiary. He was serving time for other crimes.
Which brings us to the core legal issue. What was the exact question the Supreme Court had to answer?
The issue is this. Can a defendant, Daniel, be found guilty of substantive offenses committed by a co-conspirator, Walter, in furtherance of their conspiracy,
Right.
based solely on the existence of the conspiracy, without any direct participation or aiding and abetting in those specific acts?
So can the conspiracy charge itself just drag all the other substantive charges along with it? What rule of law did the court apply? Could you state the full black letter rule and break it down into its testable elements for us?
Of course. The court applied what we now all call the Pinkerton rule of vicarious liability. The rule holds that a conspirator is liable for the substantive crimes of his co-conspirators if certain conditions are met. It breaks down into a few key elements. 1, the defendant was a party to an unlawful and, importantly, a continuous conspiracy. 2, a substantive offense was committed by a co-conspirator. 3, the offense was committed in furtherance of that conspiracy. 4, the offense fell within the scope of the unlawful project. 5. The offense was reasonably foreseen as a necessary or natural consequence of their agreement. And finally, number 6, the defendant did not take affirmative action to withdraw from the conspiracy before the crime was committed.
Thank you. That is a robust list. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the whole idea of a continuous conspiracy and withdrawal?
Okay. So the sub-issue here was whether Daniel's imprisonment or just his lack of direct action counted as a withdrawal from the conspiracy. You might think being in jail is a pretty good way to stop your involvement.
Right. It seems like the ultimate withdrawal.
You'd think so. But the court analyzed this by relying on an older case, Hyde v. United States. And the principle there is that once an unlawful scheme is joined, it is presumed to be continuous until its full fruition.
Well, so the conspiracy has a life of its own, a momentum.
Exactly. The court applied this directly to Daniel's facts. They found there was no evidence of any affirmative action by Daniel to disavow or defeat the purpose of the conspiracy. Mere absence or even imprisonment was not enough to break that criminal partnership. The court used this really intense phrase, saying he was consciously offending through every moment of the conspiracy's existence. Unless he did something to actively stop it, he was still in.
Consciously offending while sitting in a cell. Wow, understood. Now, what about the second element, the connection between the act and the conspiracy, the in furtherance requirement?
Right. The sub-issue here was whether Walter's specific crimes, the tax fraud, the whiskey dealing, were distinct from their general agreement, or if they were a core part of it. Daniel's lawyers tried to rely on a previous case, United States v. Sell, which had held that just participating in a conspiracy wasn't enough to convict for the substantive offense without direct participation.
He was basically trying to argue, look, I agreed to the overall plan, but I didn't do that specific thing.
Precisely. But the Supreme Court, they rejected that argument. In their analysis, they took a much broader view. They applied the facts and found that the unlawful agreement contemplated precisely what Walter did. His acts were the execution of the enterprise they had agreed upon. So because the partnership was formed for this specific illegal purpose, the acts were definitely in furtherance of it.
So if the plan is working as intended, you are liable for the work that gets done. Makes a certain kind of sense. And what about the limiting elements, scope and foreseeability?
The sub-issue here is, essentially, were these crimes some kind of ramification the brothers couldn't have predicted? Something wild or completely off script. Justice Douglas notes in his analysis that, quote, a different case would arise if the act was merely part of the ramifications that could not be foreseen.
Like if Walter had done something completely random and unrelated.
Exactly. But in applying this to the Pinkertons, the record showed these specific crimes, the tax evasion, the whiskey transport, were the exact purpose of the partnership. They weren't a surprise. They were the natural intended consequence of the agreement. So absolutely within the scope and absolutely foreseeable.
And after analyzing all those elements, what was the court's final conclusion?
The holding was affirmed. The judgment against Daniel was upheld. The court concluded that the criminal intent to do the act is established by the formation of the conspiracy itself. Daniel is guilty of Walter's crimes.
Okay, that is heavy, really heavy. Let's make sure this sticks for the listener. I want you to give me a visceral, hypothetical, something, I don't know, gross or extreme, to show just how far this rule really reaches.
Okay. Let's take it out of tax fraud and into something more violent. Imagine you agree with a friend to rob a pharmacy to steal drugs. That agreement, that's the conspiracy. You agree that your role is just to wait in the car. That's the agreement. You even specifically tell your friend, hey, no violence, just grab the pills and run.
Okay, so I've explicitly set a limit. No violence.
You think you have. But your friend goes in and the pharmacist resists. Your friend panics and shoots the pharmacist. That's the substantive offense. Now, under the Pinkerton rule, even though you never touched the gun, never even entered the store, and you specifically said no violence, you are in a world of trouble.
How much trouble?
If a court finds that shooting someone is a reasonably foreseeable consequence of an armed robbery, which, let's be honest, they almost always do, you are liable for that shooting, just as if you pulled the trigger yourself. You are the partner in the murder.
Even though I explicitly said no violence.
The law's logic is that once you set a criminal plan in motion, you own the foreseeable risks associated with it. Violence is a known, foreseeable risk of robbery. Therefore, you can be found guilty of murder by proxy.
That sounds incredibly harsh.
Yeah.
Did everyone on the Supreme Court agree with this partnership in crime theory?
No, not at all. And this brings us to the critical dissent by Justice Rutledge. He strongly, strongly disagreed with this entire outcome.
What was his main argument against it?
He had three main points. First, he argued this whole decision completely violated Congress's intent. Congress, he said, defined three distinct classes of crime. 1, completed substantive offenses. 2, aiding and abetting. And 3, conspiracy. Rutledge argued that by blurring these lines, the court was just ignoring the clear distinctions that Congress prescribed.
He's saying the court is mixing up legal categories that are supposed to be kept separate.
Correct. His second argument was about double jeopardy. He was worried this rule either punishes a man twice for the same offense or it convicts one man for another's crime. His thinking was, if the conspiracy is the crime of agreement, why are we stacking more charges on top of it for the very same agreement?
And his third point.
He argued it was just a massive, dangerous overextension of liability. Rutledge pointed out that this creates a vicarious criminal responsibility that is even broader than civil liability for business partners. You know, in business, you might lose money because of your partner's mistake. Here, you lose your liberty. He warned that this loose treatment of distinctions could lead to people being imprisoned for crimes they never actually committed or even aided.
That is a fair warning. It really does seem like a very slippery slope. All right, I want to boil this all down into a tool the listener can use immediately. If I'm looking at a fact pattern on an exam or maybe my own life choices, how do I diagnose Pinkerton liability?
We can break this down into a step-by-step diagnostic checklist. If you're looking at a situation, just ask these questions in order. Number 1, identify the conspiracy. Is there an agreement to do something illegal? If there's no agreement, you stop. If yes, you proceed.
Okay, first find the agreement.
Number 2, check for withdrawal. Did the defendant do an affirmative act to disavow the plot? And remember, silence is not enough. Being in jail is not enough. You pretty much have to notify your co-conspirators or the police that you are out. If they didn't do that, they're still in.
Right, affirmative acts. Got it.
Number 3, identify the substantive crime. Did a co-conspirator commit a specific separate crime, like the tax fraud or shooting the pharmacist?
Okay.
Number 4, apply the Pinkerton test elements. Ask 3 quick things about that crime. Was it in furtherance of the conspiracy? Was it within the scope of the original plan? And was it reasonably foreseeable?
The big 3.
And finally, number 5, the conclusion. If you answered yes to all of those test questions, then the defendant is guilty of the substantive crime in addition to the conspiracy charge itself.
That makes it crystal clear. It's a cascading liability. You start the snowball rolling, and you're responsible for the whole avalanche.
That's a perfect analogy for it.
So what does this all really mean for us? I guess it means you are your brother's keeper, legally speaking, if you enter into a criminal agreement. The law just does not let you compartmentalize your guilt.
It connects right back to that idea of agency. You can't accept the potential benefits of a criminal partnership, the loot, the profit, without also accepting the burdens. And those burdens include every single foreseeable act your partner commits to get that loot.
I want to leave the listener with one final thought to mull over. We learned today that sitting in a prison cell isn't enough to withdraw from a conspiracy. Silence isn't withdrawal. So here is the provocative question. If imprisonment, which effectively removes you from society, doesn't remove you from a conspiracy, what exactly does a person have to do to escape a criminal machine they helped build? Does the law essentially demand that you have to betray your brother to save yourself?
That is the dark bargain of conspiracy law.
Thank you for listening to this deep dive into Pinkerton v. United States. We will catch you on the next one.